Act, because so many of the questions that I see revolving around leave, accommodation, how to handle employee medical issues revolve around new ADA and what can we do, what are we not allowed to do, what are employees' rights, what are employers' reasonable accommodation obligations. So let's look back to where we were the good old days. In the past, most employees, most applicants also were not covered by the ADA because their physical or mental conditions weren't serious enough. They just did not reach the bar of meeting a qualified individual with a disability. Only certain conditions you could pretty much guarantee were disabilities, but otherwise we looked at conditions that in their mitigated state, such as an insulin-dependent diabetic, we would look at someone while taking insulin, an epileptic, someone while taking their seizure medication, and when examining them that way, they wouldn't meet the threshold of disability. So most of the time, when employers were making assessments on physical conditions or leave issues, the question never went beyond, is the person disabled? Because they were not. And that was not an issue. Not so anymore. In the past, most cases involving backs, knees, wrists, other musculoskeletal conditions were not disabilities. At the hiring stage, if there was a post-conditional offer medical exam, employers could screen out someone, for example, with a history of bad backs for a manufacturing or production job, and it just wasn't that big an ordeal. Not so anymore. Being unable to work in a particular workplace was not a disability. Not so anymore. And we've already talked about the applicant screening out. But when the ADA was enacted, and it was actually enacted in 1991, went into effect in 1992, it was intended to protect a broad scope, a broad range of individuals in the workplace and prevent discrimination and provide equal employment opportunity. But as the courts got hold of the ADA, the definition of disability was very much whittled down so that most plaintiffs, if they brought a lawsuit, never got past the question of is this person disabled because they were not. Now, what do employers have to be ready for? Bad backs, carpal tunnel, depression, post-traumatic stress disorder. Especially these mental conditions. I've seen a lot of these surface in the last year or so. Migraines, irritable bowel syndrome, chemical sensitivity. I wonder if anyone on this call has dealt with that. Allergies and asthma. And why I say to get ready for those, that looks like a common set of maladies.